Welcome to the shit show. A three-ring circus in the canvas of your mind, with all the bells, whistles, and imaginations of your delusion of this circus called life, where you were the ringmaster. Then you handed the keys to some silly-ass clown.
Step right up to the twisted parade where the calliope hums and the shadows won't fade. Brass horns blare but the tune's off key. A carnival king grins, bow down to me. Bass drum pounds like a runaway heart. Snare snaps crack, the crowd comes apart. Laughter coils like a snake in the grass. You're part of the act now, so don't slip through the cracks. Oh, the carnival king rules with a crack crown. Organ riffs spin as the tent spins around. Whistle, shriek, roaring, but your feet stay glued. They'll feed you to clowns if you dare to boo. Mirrors warp what you thought you knew. His voice drips honey, but the truth's askew. I'm the ringmaster, jester, and beast. A circus of chaos where the nightmares feast. Lions yawn, but their teeth gleam bright. Fire eaters spit embers to light up the night. The midway's a maze with no exit in sight. The smirk says you'll love every second of fright. Oh, the carnival king rules with a cracked crown. Organ riffs spin as the tent spins around. Whistle, shriek, run, let your feet stay glued. He'll feed you to clown if you dare to boo. The calliope wheezes a funeral march. Balloons pop like thunder in the pitch dark. He'll juggle your fate with a wink and a sneer. The show never ends. Why'd you think you're here?
Greetings, everybody. Keith here. Hoping everybody's having a good day, enjoying life, living life, loving life. I want to remind everybody, of course, hit that like, share, and subscribe, as it said. And appreciate Jack and his crew for coming over. May not be the normal stream that people are used to. I'm going to be reading some of the documentation I drew up. I've got a forcible entry and detainer coming up on Monday due to some chaotic environmental nuisance and nothing being done about it. And, of course, that allows things to escalate. And they try to turn around and they're trying to evict us for clear and present danger because of the escalation. So first, what I'm going to do is I've got the research material on specific cases, and I'm going to read off that. And I will drop the link if anybody wants to come up. So just let me know. But I'd like to get through the paperwork first. So please pay attention. I think it's important for anybody that goes through this. And of course, don't believe me. Don't believe the neighbor. Don't believe the government. For crying out loud, don't believe your mother. Do your research so you know. Because every situation is different. And so I'm going to start off with the leading case that we're referencing here for the forcible entry and detainer is Hillview Associates versus Bloomquist from 1989. And it says this is the most significant Iowa case regarding retaliatory eviction. The scenario is a group of tenants formed an association to complain about maintenance and management issues. And that's what we're talking about with your forcible entry and detainer evictions. It's always under a maintenance schedule, and that's in your statutory code for the landlord's statutory duty for maintenance issues. And when we talk about tenants breaking their lease, that is a maintenance issue. And so after a heated meeting with the management of this association, the landlord turned around and served them with notices of termination. And that's a retaliatory event. It says the result, the Iowa Supreme Court held that the tenants had a valid defense of retaliation. The key legal rule, the court established that once a tenant proves they made a good faith complaint about maintenance or health and safety issues within 6 months of the eviction filing, there's a presumption of retaliation. Now in Iowa, they've changed that from 6 months to a year. It says the burden then shifts to the landlord to prove non-retaliatory reason for the eviction. And what we're looking at here is my companion has a disability. It's a frontal temporal dementia. And so when there's excessive noise and everything coming from the upstairs apartment, namely children running, stomping, screaming, hollering, jumping, and all that, all day long from 8 a.m. till 9, 10 p.m., sometimes even later. We've heard them at 1:30 in the morning. We're talking about a 2-bedroom apartment with 3 adults and 3 children. And that's might seem excessive, but we've had the same condition where we had 3 adults and 3 young children living in the apartment upstairs before and never had this issue. And the lease term we're talking about is the noise ordinance, which talks about incidental noise. Now, incidental is here and there, not constantly all day long, every day. So we called in and complained about that. And rather than the landlord doing the statutory requirement under that maintenance to give the neighbors upstairs a 7-day notice to cure, or they would face eviction, the landlord failed to do that. So it allowed the neighbors upstairs, despite my complaint to them several times, to escalate. Now I no longer complain. I pound back, and it disrupts the other neighbors. So the other neighbors are calling and complaining about our situation. So the outcome for the tenant, for several of the tenants, the eviction was blocked because the landlord could not overcome the presumption that they were being evicted for complaining. So that's telling us there's a presumption in law that there's a retaliation if I make a complaint and then we're evicted shortly thereafter within the year. The next case, Staley versus Barclow, 2008 or 2013. Although this case dealt largely with illegal lease provisions, it reinforced the tenant's right to sue and defend based on the landlord's failure to maintain the premises. The scenario there was the tenants challenged various lease terms and the landlord's failure to perform repairs. The result was the Iowa Court of Appeals affirmed that landlords have a non-waivable duty to maintain fit and habitable premises under Iowa Code 562A.15. And this is similar to the, like I said, the noise ordinance. If somebody was sitting there and lighting off fireworks all day long, every day, that would be a noise ordinance violation because it's not incidental. Okay, it's not one firecracker here or there. So the result is that they have that non-waivable duty to maintain fit and habitable premises. And again, this is in reference to my companion who gets very upset when she can't have her peace and quiet. her frontal temporal dementia is an emotional imbalance. And so I've learned to deal with that. But on my own, that's an incidental thing, because for her, her emotional imbalance is only incidental to certain situations. But when you have a situation that is consistent and constant, that emotional imbalance is now consistent and constant. And that causes not an incidental reaction between her and I. The impact on the forcible entry and detainer is this case often cited in forcible entry and detainer defenses show that a landlord's attempt to evict a tenant who is demanding these statutory rights is retaliatory in nature, not by statutory code. This goes to that good faith and fair dealings part. The third one is B.I.G.S.C.U.N.T.S versus D.U.M.B real estate 2022. This case provides a more recent look at how these defenses are handled. The scenario: the tenant, Bark, complained about various maintenance issues, non-working washing machines, ACs issues, and neighbors' disturbances. The landlord eventually declined to renew the lease. The outcome: while the court in this specific case eventually found for the landlord, because the tenant had already vacated and the retaliation wasn't proven to be the primary motive for a non-renewal, the court reaffirmed that retaliation is a valid defense in possession action if the tenant can show the victim was triggered by maintenance complaints. Important exceptions. Under Iowa Code 5628.36(3), a landlord can still win the forcible entry and detainer even if they were negligent, if the tenant is behind on rent. We've always been on time, never failed to pay rent on time, have never had an eviction on our record. And the next one is the tenant is behind on rent for like if you withhold, excuse me, not next one, but the next part of that is that if you withhold rent because the landlord is failing to maintain repairs and stuff, the procedure for that under 5628.27, you may lose your retaliation defense. So you have to stand firm and stand your ground in good faith. Pay your rent, stay there, force them to go through the forcible entry and detainer. Do not accept a 3-day notice to quit. That's not a valid court action. That's just a notice by the landlord that they want to evict you. You have to force them. Okay? The landlord needs the tenant to move out to perform actual repairs is the other exception. There are no repairs that need to be made. The remedy in this case for the maintenance issue is not a repair issue. It's an incidental noise issue that is not incidental. The Supreme Court case that brought about the retaliation foundation of defense for forcible entry detainer, resulting in the Uniform Residential Landlord and Tenant Act, was Lindsay versus Norman, 1972, and this is a U.S. Supreme Court. This case is the reason why retaliation and maintenance defenses are handled primarily at the level or state level rather than the federal level because of the statutory requirements. They're not federal requirements. The scenario: tenants in Oregon refuse to pay rent because their landlord failed to maintain the building in a habitable condition. Specifically, the city had declared the house uninhabitable. They challenged Oregon's eviction laws, arguing that the law violated their due process and equal protection because it did not allow them to raise bad maintenance as a defense for not paying rent. That's where that came from. But at the state level, non-payment of rent after you have an issue allows the landlord to move forward with his forcible entry and detainer. This is why you have to stand your ground, pay your rent, and that's what provides you protection. The ruling in the U.S. Supreme Court upheld the landlord's right to summary eviction process. The key takeaway is the housing is not a constitutional right, no matter what you think about domestic tranquility and general welfare in the Constitution, it does not guarantee the constitutional right of housing. The court famously stated there is no constitutional guarantee of access to dwellings of a particular quality. This is why you're allowed to stay in tents if you're homeless. State law controls. The court ruled that states are allowed to treat duty to pay rent and duty to maintain the property as separate issues, again, because it's statutorily regulated and not federal code. This means the state can choose to allow an eviction for non-payment, even if the landlord is breaking maintenance laws. Again, reiterating, that's where it was established, is in the Supreme Court. You can go ahead and just move out. But if you do so, you're likely to lose any future cases in suit. Procedural victory. And this is, before I go on any further, this is what we're attacking, is the procedural legal error. Not by the court, but by the landlord. The procedure legally was to issue a 7-day notice to cure to the upstairs tenants. They failed to do that. That is the procedural legal error. The court did strike down a requirement that tenants pay a double bond, twice the rent, just to appeal an eviction, ruling that this unfairly discriminated against poor tenants. Why this matters? Because the U.S. Supreme Court declined to create a federal habitability defense. The Iowa Supreme Court and the Iowa legislature became the final word on the matter for Iowans. So again, don't believe me, don't believe the neighbor in a different state. Do your research according to the state you live in. In response, the legal climate created the case like Lindsay in Iowa and other states adopted the Uniform Residential Landlord and Tenant Act. This is where current protections come from, not the federal. Iowa Code 562A.36. This was specifically written to provide protection that the U.S. Supreme Court declined to grant in Lindsay. It ensures that even if housing quality isn't a federal constitutional right, retaliation for reporting maintenance issue is a protected right under Iowa law. Federal Circuit influence. While not the U.S. Supreme Court, the D.C. Circuit case, Edwards versus Habib, 1968, is the spiritual ancestor of Iowa's law. It was the first major case to rule that a landlord cannot evict a tenant simply for reporting housing code violations to the government. And that's where we have a sticking point, because there were other maintenance issues that came about before the incidental noise. Iowa, or all states, have a filter regulation that those filters in the furnaces are supposed to be replaced every month. Well, since we got a new management company, we had not gotten a new filter. So we called in and requested for a new filter. And rather than just complying with state statutes and giving the filter once per month, which their records would show by inventory that they didn't disperse such filter, they requested that I send them a photo. Again, sorry, I am not the maintenance tech. I am just the tenant. The maintenance is on the landlord. I am not going to send you a picture. A couple days later, they still hadn't come by with a new filter. So I simply texted and gave her fair warning that if we did not receive a filter for the furnace, we would simply do by law our duty and call the fire department for an inspection for safety and habitability reasons. Bingo! And that day, 11/5 of 2025, we got a filter. We haven't received a filter since. 11/5 was a new filter. December 5th and January 5th, we were supposed to get a new filter. So it's now been 2 more months since we've not gotten a filter. So again, a repeated action, failure to provide the filter, is a pattern of practice. Now we live in Iowa, and so we have snow. And again, the maintenance in regards to snow removal is on the landlord. However, they failed to do that, and that is a very important issue, again, as to safety and habitability with my companion and her physical disabilities. 2 knee surgeries and multiple surgeries on her feet. She has to walk with a walker, and having unshoveled snow or unshoveled sidewalks does not allow for her to be able to do that safely. So I myself had to go out and shovel the walks. Okay. Now, I'm not the only one that has these complaints. The neighbor right next door also has a complaint about a neighbor, the upstairs tenant, parking in front of her garage. Also, the neighbor is the one doing the shoveling of the back sidewalk so they can get to their car. The neighbor also has not received a new filter in 3 months. Pattern of practice, 2 witnesses. Now, entrance into the court. It's imperative, again, like I said, to contact the landlord and make a record. The same thing with the courts. When you walk into that court, you have to establish a record. So I've drawn up some questions that I'll be asking the court to make sure that the court is operating in good faith and fair dealings as well. So I've got, first of all, a request for a court reporter per Iowa Code 602.6603. Is there a reporter present, or is this being recorded? It better be yes. If he answers no, it shows absolute contradiction to his duty, which is a fiduciary duty, and bias. Is the device currently active, and may I have the name of the person responsible for the log of this record for an appeal? And this is important because you need to get those transcripts. And I'll also note here that I suggest, if you have the money, to hire your own court reporter. That way those transcripts can't be doctored. Your Honor, for the record, are you presiding over this matter today in your Article 3 judicial capacity under the authority of the Constitution as its constitutional protection under Iowa law, as it relates to my natural person capacity in relation to health and safety, not maintenance, and not the legal person of capacity of record? He better answer yes. Is this court currently proceeding as a court of record according to the common law, i.e. my natural person, or is this an administrative proceeding under statutory rules, i.e. legal person / firm name? Not my name, naturally, but a firm name where it too is doctored. Does the court recognize its obligation to uphold the United States Constitution and the Constitution of the Republic of Iowa as the supreme law of the land in this specific case? And I'll remind you folks, in Iowa and I believe most states, eviction is an equitable action. Will the court be applying the rules of evidence and common law protections of due process throughout these proceedings? Again, he better say yes. Does the plaintiff have a verified claim of specific injury in fact, or is this action based solely on an alleged violation of administrative code? If they don't have a witness specific to the injury, i.e. the tenant upstairs who has issued a complaint after mine stating that I was threatening him, posing clear and present danger, then there's something wrong. If he does not show up in court professing his injury, saying that I threatened and put him in fear, then case is lost. Because the management can't be first-hand witness. They are second person because they're the ones that the first person filed a complaint with. It has to be the tenant upstairs. Does the court intend to prioritize statutory summary procedures over my constitutionally protected rights to property and due process? Again, he better say yes. If the court chooses to deviate from the common law or constitutional protections, will the court provide a written, finding of fact and conclusion of law, explaining the jurisdictional basis for doing so. Again, if they do so, they better say yes. If any of these answers is no, or they determine that they are providing a summary judgment on administrative code, then, Your Honor, I respectfully request a clarification. Is it this court's position that the Iowa Administrative Code supersedes my constitutional right to due process? And if he says no, then he contradicts himself in any other no or admittance to administrative procedure. My statement of defense. Your Honor, I am Keith, and this is Joyce. I'm 60, she's 70, and I am a person with disability, currently going through cancer issues, still recovering, and she has frontal temporal dementia, as well as the 2 knee surgeries and multiple foot surgeries that I mentioned. I am here today to contest this eviction because the landlord has failed to meet the legal burden of clear and present danger under Iowa Code 562A.27a, which is the one they're using against us. The lack of evidence for clear and present danger. The landlord alleges that I'm a danger because of a first-hand witness, the tenant upstairs, saying he was threatened and was in fear. However, on December 24th, Christmas Eve, 1:30 p.m., the police department was called for disorderly conduct. The threat, the clear and present danger. Officers Sullivan and Payne of the Waterloo Police Department responded to my home. After investigating the situation, the officers determined that the noise from the upstairs apartment was not incidental, but was a legitimate and continuous disturbance. The stomping, jumping, screaming, hollering, running, and all that. They admitted to it. They chose not to file a police report or charge me with any offense because they recognized I was responding to an escalated situation caused by the neighbors upstairs. I have subpoenaed these officers to testify to these facts. Without a criminal act or a genuine threat, the landlord's claim of clear and present danger is factually unsupported. 3, provocation and landlord's failure to act under Iowa Code 562A.15, the maintenance issue. A landlord has a duty to maintain a fit and safe premises. I notified the landlord via phone and text that the upstairs neighbor was mocking us and stomping, running, jumping, screaming, and hollering. And I'll note here that I did address the neighbor first before I addressed the landlord. I first went up and knocked on their door. First time, they answered. The gentleman claims he doesn't understand English. The woman I know understands English. I told them they needed to quiet it down. It was upsetting us downstairs. It was too loud. They said, okay, but it continued. So again, a couple days later, I went up and knocked on the door. This time they refused to answer. And this is where the lady answered through the door, not by answering and opening the door, but through the door, and mocked us, saying, what, don't you have children? It doesn't matter whether I've had children. The issue here is incidental noise. Then, of course, I addressed them several times before I contacted the landlord. Then when the landlord didn't do anything about it, then I escalated. Then I grabbed a board, and every time I heard him stomping, running, jumping, screaming, and hollering, I started slamming it on the door frame, letting them know it was too obnoxious. They still don't want to settle down. So then I took that board and I went up and I knocked on their door with the board. letting them know, because I'm not going to knock that hard on with my knuckles, but I know that knocking on that door with that board is going to be loud. That's all it was. The landlord responded after I texted and called him by calling it incidental noise and refused to intervene, refused to uphold their statutory duty to file or give the neighbor upstairs a 7-day notice to cure. In other words, they had to stop with the excessive noise, or otherwise they would be evicted. By not doing so, and then taking their complaint that I was threatening, it's now on the landlord failure to do what they were required by that administrative statutory law. They're the ones subject to that law, not me. I'm subject to good faith and fair dealings, and I operate in good faith and fair dealings. If one seeks equity, they must do equity. By failing to address the neighbor's chaotic environmental nuisance, the landlord allowed the situation to escalate. My reactions were a direct result of being trapped in a hostile environment that the landlord refused to manage. And it's only me reacting to the neighbors because my companion can't. She reacts to me. I'm the one that has to deal with her and her emotional distress. That's what I was trying to quell. 4, request for reasonable accommodation. When the landlord gave notice of a 3-day eviction under the Americans with Disability Act, they are supposed to accept what's known as a request for reasonable accommodation. In other words, people with disabilities can't just pack up and move in 3 days. They're disabled. So they're requesting a reasonable accommodation, which is an extension of time to allow for that disability. Otherwise, that is discrimination against that disability. That is a suitable offense. That is a constitutional violation. Because I am a person with disability, the law requires the landlord to provide reasonable accommodations rather than eviction if my conduct is related to my disability and can be managed. I have formally requested that the landlord pause this eviction and instead address the noise triggers from the upstairs unit. The landlord has refused this accommodation, which I believe constitutes housing discrimination under the Fair Housing Act. Okay? And again, that's that thing where they deny the statutory responsibility to do so. So a pattern of practice, twice, they denied their statutory responsibility to act appropriately through proper notice and proper request for reasonable accommodation. The landlord is attempting to use emergency, clear and present danger eviction to remove an elderly, disabled tenant rather than dealing with a neighbor dispute they ignored. I ask that this case be dismissed for lack of evidence, or at minimum, stayed, paused, to allow for a fair housing investigation as it relates to the ADA. This is an action in equity, and the principle of equity requires that the plaintiff come to court with clean hands. He who seeks equity must come with clean hands. The landlord has failed this standard in an equitable action. We, in good faith and fair dealings, gave proper notice both to the upstairs tenant and the landlord of the disturbance on December 16th and prior. Instead of fulfilling their duty under Iowa Code 5628.15 to provide a safe and quiet environment, the landlord chose to ignore the provocation. The landlord is now using a clear and present danger filing as a shield for their own failure to manage the property. We urge the court to hear the testimony of Officers Sullivan and Payne. They will testify that the disturbance was real, it was caused by the upstairs tenants, and that they, as law enforcement, found no cause to charge the defendant. Not only did they not charge the defendant, but there is not even a police report or service notes, just a call report noting that they came out. So we need to have them on the stand so they can give their determination of why they discerned that there was no clear and present danger. Questions for the officers. Officer, when you arrived, did you speak with the upstairs tenant regarding the noise behavior reported by another resident? They'll say yes. Based on your questioning of the upstairs tenants, did you find Keith's complaints about stomping and disorderly conduct to be credible or supported by your observations of the tenant's demeanor? Again, they'll say yes. So they'll confirm my complaint is valid and that theirs isn't. Did you specifically instruct or warn the upstairs tenants to cease the noise or change their behavior to avoid further escalation? And again, they will say yes. Did you speak to another neighbor named Gabriel who interpreted for the neighbors? This goes to the issue that they didn't understand my communication. And that's bullshit because, again, the neighbor also addressed me when I went up there and knocked on their door several times. He speaks English. He speaks their language. And he told me specifically he would talk to them and tell them they needed to quiet down. So now we have two people, the officers and the neighbor, that told them they needed to quiet down along with me. 3 or more witnesses. What sense of the situation did you gather from Gabriel as to the initial concern and escalation? And did he give you any timeline of events? Now, I don't know if he gave him any timelines, but I guarantee you that Gabriel told him that he had, in fact, talked to the neighbors before about the issue and asked them to quiet down. In your professional judgment, did you see any evidence that Keith posed a clear and present danger to anyone? Or did it appear they were responding to a persistent, unaddressed nuisance? And again, when they walked away and didn't charge me with disorderly conduct and didn't file a police report or service notes, that is clearly evidence on the record, off the record, that they, under their professional legal expertise, saw no such evidence. So the record still bears no evidence of clear and present danger. Is it true that you chose not to file a criminal report or issue a citation against Keith because you surmised the situation was a civil neighbor dispute exacerbated by noise issues? And again, they'll say yes. Did the upstairs tenants mention to you whether the landlord had issued a specific warning to them in a 7-day notice to cure? And again, they'll probably say no, because I don't know that one has ever been filed because if it were given to them, because if it were, they should have quieted down. And if they didn't, then they should be the ones that were evicted. So again, evidence that's not on the record that evidences that the landlord failed their maintenance duty to provide that notice. Your Honor, the officer's testimony shows that even without hearing noise themselves, their investigation led them to believe the upstairs tenants were the source of conflict. They warned them, not me. The officer's discernment proves that a reasonable person could see this was a nuisance. Yet the landlord, who was given notice weeks prior, so understand, this isn't just 1 or 2 incidents. This went on for weeks. Refused to issue a 7-day notice to cure to those tenants, choosing instead to ignore the initial cause. The fact that these officers, who are trained to identify danger, walked away without filing a report is the strongest evidence that no clear and present danger ever existed. The landlord is acting blindly to the initial cause. We gave notice on December 16th. The landlord had the power to stop the escalation by issuing the 7-day notice to cure, and instead they issued a general notice that did nothing to protect our right to quiet enjoyment. The general notice was just a text to all tenants reminding them of the lease term about incidental noise. It's not a warning. That's just reiteration of the noise term. They're required again, by statutory law, to give the neighbor a 7-day notice to cure. That's why I have that question in there. And the record will show that they gave none. My agitation was a foreseeable result of the landlord's bad faith performance of her duties. This is the same agitation of Jesus flipping the tables, folks. As this is a case in equity, the landlord cannot ignore root cause and then seek to evict the victim for reacting to it. I remind you, this is an equitable action in these courts. Then I've got some questions for the neighbor, but I'll leave them out to keep her off the record. But I assure you, Your Honor, the neighbor's testimony provides a second witness to a pattern of practice by the new property manager, Listy Wickman. Out of chaos comes order. In other words, the chaos, or rather negligence, of Listy Wickman to her statutory duties under Iowa Code shows a pattern of practice that brings her to full culpability in these matters. We believe rather than deal with us as tenants, she is retaliating to remove us unjustly. This is clear and convincing evidence under Iowa Code. As a part of the remedy, we seek for damages in the amount of $3,000, which we feel is fair and reasonable for the chaos we've been subjected to, as well as having to prepare for these proceedings. And I'm telling you, folks, we have spent hours upon hours upon hours looking for other places to move to. It's a low-income housing situation here, so our rent is kind of low. But everywhere we look, the rent is going to be higher. As well as all the time I spent researching to provide all this stuff so I can present this case in court without an attorney, without representation, without representing the facts, but actually going to the facts that are already on the record and the facts that are missing that should be there. I'm not going to represent anything. It's already there. This includes research and time spent looking for another place to live and document production, all my paperwork, cost, printer ink, papers, all that. And that's costly. I'm much more expensive than an attorney if you want my help. But I do it cheaply for myself, but it's still not real cheap. In short order, limitations of disabilities, both mental and physical, it is extremely hard to find a place for both my companion and I, and the support companion for my wife, Eddie. You know, places that allow dogs, particularly large dogs. Closing statement. Request for equitable relief. Your Honor, we are here today in a court of equity. The law of equity is not a cold mechanism. It is a search for truth and fairness. As the scripture says in Isaiah 1:17, we are called to seek justice, encourage the oppressed, and defend the cause of the fatherless. Today, that cause belongs to an elderly and disabled resident who has lived in good faith while being subjected to a trial of environmental discord. The principle of clean hands. Equity requires that a plaintiff come to these equitable actions with proof that they followed equity. The landlord has failed this standard. On December 16th and 17th, the defendant did exactly what a good tenant should do. They reached out for help. They gave notice to the continuous non-incidental stomping, running, jumping, screaming, hollering, and mockery from the unit above. The landlord chose to be blind to this distress, labeling it a legitimate nuisance as incidental. By ignoring her duty to maintain a fit and safe and healthy premise, the landlord allowed this crisis to grow. To now use a clear and present danger filing to punish a disabled person for reacting to a nuisance the landlord refused to fix is the very definition of unclean hands. We have heard the testimony of Officer Sullivan and Payne and a neighbor. These officers are experts on public safety and they were at the scene. They witnessed the environment. They chose not to file a report or charge the defendant. They recognized that the danger here was not the resident, but the environment. If the police sworn to protect the peace did not find danger, then this court should not find one today. The shield of retaliation under Iowa Code 562.8.36, there is a presumption of retaliation when eviction follows a good faith complaint. And like I said earlier, it used to be 6 months. Now it's a year. So if we complained a year ago and they decided at the beginning of our lease for a year that they didn't want to renew the lease and nixed our lease at the end of the year, that could be considered retaliation. The defendant spoke up for their right to peace in December. The landlord responded with an eviction in January. This is not a pursuit of safety. It is a pursuit of convenience at the expense of a vulnerable life. Conclusion, a request for mercy and justice. Jesus taught that a house divided against itself cannot stand. She's divided in her mind. That's the house, folks. And that we should first remove the log from our own eye before seeking the speck in a neighbor's eye. The landlord has a log of negligence in her eye. We ask this court to act in equity, dismiss this action for clear and present danger, or for lack of evidence of clear and present danger. Order a reasonable accommodation that requires the landlord to address the upstairs nuisance or provide a transfer to a safe, quiet unit or another dwelling. Restore the peace that was lost when the landlord ignored the first cry for help. As Micah 6:8 reminds us, we are required to act justly and love mercy. We ask the court to do both today. Requested remedy. The defendant requests that the court acknowledge the presumption of retaliation based on the December 16th complaint. Hear the testimony of Officers Sullivan and Payne and the neighbor regarding the lack of clear and present danger and pattern of practice of failure of maintenance duties. Dismiss this action as retaliatory and discriminatory filing. Like I said, Americans with disability, they're required to respond appropriately to their requests for reasonable accommodations and extend that civility. An extension in good faith. We would expect a rental credit for the undue stress and anxieties if we are to stay. In other words, it would not be a loss if we stayed another month and were then not required to pay rent, but extend that as part of the remedy for damages as a credit, rather than them paying us. They just accept a credit that we just automatically get another month or two, or whatever the court might decide. As well as to further ensure our health and safety in future incidents. If that were be the case, they need to do something about the upstairs neighbor. Settlement. The eviction is dismissed with prejudice. The landlord provide a reasonable accommodation by transferring the resident at the same rent rate or subsidizing any extra, or allowance to stay with actual damages if awarded, used as credit. So if we're given $3,000 and are allowed to stay, which we might prefer, even despite the circumstances, which I doubt. I don't like dealing with people that are ignorant and don't deal in good faith. Then that whole $3,000 would just go towards rent. Actual damages to include stress on both tenants and any moving or legal expenses and expenses incurred for filings, recordings, services, notary, accepted, etc. And then I've got an affidavit of fact regarding a landlord non-compliance and retaliation that I cannot read. That is specifically for the court. And so basically, we've got solid standing. And I've talked to several people, both on both sides of the fence there, attorneys and landlords, and as well as a homeless coordinator with the local mental health institute in regards to my companion, the homeless caseworker. Every last one of them says I've built up a very strong case and that they honestly believe we will absolutely win. And I don't have much doubt, except for the fact that I know how these courts operate through previous 94 cases. So I'm fully confident, but there's still that tinge of that corruption that is systemic that I've been talking about for a long time, folks. And this is why I tell you, don't believe me. Don't believe the neighbor. Don't believe the government. And for crying out loud, don't believe your mother. Do your research so you know. That way, when you present it to other people, they will see that you know. They will have the eyes to see that you know. And this is why I say when I walk into that court, that judge will see that I know. And if he makes one error in bias, he's on the docket too. I'll drop the link if anybody wants to come up and talk, chat, opinions, observations, perspectives. In the meantime, I'm going to go back through and see who all is here. I want to thank everybody for joining me. That's for sure. We've got RGO. Thank you. Denizen, Logical Spark, 2 packs of sugar. Greetings, everybody. Jack Talcott, IMAX. Thanks again for the raid, everybody. I appreciate it. The Chatterer. Let's see. We got Lynn Maya. Please, I hope I said that correctly. Please say those 2 cases, or can someone put them in the chat, please? I read off several cases, but I can read them again. The leading case in Iowa is Hillview versus Bloomquist. Hillview versus Bloomquist. Greetings, Bubbles. Yes. Hillview Associates versus Bloomquist. We've got Staley, Staley, versus Barkalow, Barkalow, 2013. These are all Iowa cases here. We've got Bark, Barke, versus D&D Real Estate, 2022. And if it's not in chat, I'm not going to put it in chat. If you can't get somebody to put it in chat, that's fine. Just go back and rewind and listen again. I'll state these clearly. So there's the 3 Iowa cases. And then the Supreme Court case at the federal level, U.S. Supreme Court, is Lindsay, Lindsey, versus Normet, Normet, 1972. Okay. And again, appreciate everybody. We got Micah L down there. We've got John Harnick. Greetings, everybody. Dominic. We've got Captain Action, Black North. Greetings, everybody. John says, landlord needs to file a complaint with HUD, even if you're not on Section 8. I'm glad you mentioned that, because I failed to mention that in here in subsidized housing. That is absolutely correct. I can't remember exactly what the form is. I will have to check and see if I can get back on that. But there is a form on there. And this is where I get on the tenant and resident terms, because see, it's the landlord that's supposed to determine that the resident is a resident, not the resident. Okay, when you look at HUD 1 form, let me look it up. No, that's a settlement statement. Hold on, folks. Yeah, it's going to take me a bit to find that. But something else I also want to mention, guys, is all these forms are under Department of Transportation, Title 49. Think about that. Transportation is actually commerce. This is also why I have a problem with the driver's license and all that. It's all effectively a commerce scheme. So think about that. And yes, it's to verify who lives there. And again, that's absolutely correct. That's why I go on that resident term. In Iowa, resident determination is for income tax purposes, that commercial venue. At the federal level, it specifically says under 19 U.S. Code 81.0 that no residents of zone, and the zone is the foreign trade zone, the zoning improvement plan, that's where you use the zip code on your national address format. And I'll explain that sometime in the future. Again, I've done it several times. That's also deceit. You've been educated to write like that, and that's the wrong form. You should use a 4 or 5 line address that shows you are clearly, distinctly foreign from the corporate entity. Using that 3-line address like that we've been indoctrinated to implicates you as one of the officers or agents of government. So the 19 U.S. Code 81.0, no person shall reside within the zone except federal, state, or local or municipal officers or agents whose resident presence is deemed necessary. So the residency is determined as an income tax purpose, and it must be deemed necessary and not voluntary. See, equity doesn't aid a volunteer. You must give consideration. So in that resident determination, you've never given consideration. You just volunteered. So as using that form of address, you will never receive equity because you're not seeking equity. You didn't come with equity and give equal consideration so that equity would equally consider you in good faith. Got you tell me down there. Greetings, everybody. You just want to go through this. And again, just let me know if you want the link. I'll drop the link. Joshua Jonio, greetings. Yes, chapter 11, subchapter V, or chapter 15. Chapter 15 is foreign bankruptcy. Absolutely. And that is a point. Dominic Tersigni says just ponder property tax as tribute or rent. Okay, that might be consideration in that equity thing. So if you folks have owned a home and you've paid that tax on your home, you already have equity because you're using that home as a resident. Federal, state, or municipal officer or agent whose resident presence is deemed necessary by the board, and the board shall consist of the Secretary of Commerce as the executive chair and the Secretary of Treasury. You see how that works out, guys? Let's see. Anybody else? That's it, I believe. And anybody else that's down there that I haven't mentioned, go ahead and feel free to comment. Let me know if you have any questions real quick. I'm going to take an intermission. I hope you guys enjoy it real quick, and I'll be right back. But remember, The freedom flame burns only if you speak breath into it. Remember, the British are coming. Remember, he spoke that fire into people by warning them what was coming. You always have to speak truth, and you have to speak it loudly. This is the First Amendment. He was not using the First Amendment. Paul Revere was not using the First Amendment for his freedom of expression. He was using it as a warning to all the other people that have a right to know and need to know of the dangers before them. So pay attention, and I'll be right back.
Beneath the pines where the red clay cries, a preacher's words cut through the lies. With a Bible worn and a rifle tight, we march where the tyrant's shadow bites. Oh, freedom's flame burns through the night, a rebel yell for the righteous fight. Break the chains, let the truth be sworn. From dust and blood, a new dawn's born. The widow sows seeds in her husband's field. Her tears baptize the ground they'll yield. A soldier's ghost hums an old hymn's tune. We'll cross that river for the blood dark moon. Oh, freedom's flame burns through the night, a rebel yell for the righteous fight. Break the chains, let the truth be sworn. From dust and blood, a new dawn's born. When the thunder roars and the levee breaks, we'll plant our flag where the despot shakes. Through fire and flood, we'll hold the line. For peace ain't bought, lest we dare to climb. Oh, freedom's flame burns through the night, a rebel yell for the righteous fight. Break the chains, let the truth be sworn. From dust and blood, a new dawn's born.
Okay, we are back, and we have Dom and Ryan McVeigh with us. Greetings, gentlemen. Thanks for chopping in. We appreciate the support. What do you got on your mind, folks? Ryan, I see you unmuted, but we have no volume. Ryan, you there? Okay, Ryan, if you want to drop out and come back in, fix your audio issue and come back in. I don't know if you've got the wrong speakers on or whatever. There shouldn't be any issue on my end. It's the first time you've come up. I don't have any settings that would be set against you. So please drop down and come on back.
Good evening, Keith.
Greetings, Tom. How you doing tonight?
Pretty good. I'm a first timer here tonight.
Yes, I appreciate it. So what do you think, Dom?
Now you're going to force me to think. Interesting wordage as we become enslaved with this language. Well, it's kind of an enslavement. The word mint gives it away on what we think rulers are. In this case, what a landlord is. I've always found it funny when my buddies are in it and I say, listen, you've never been a landlord. What do you mean, Dom? You're in the housing business. Because a landlord, you would have to be a duke or a baron.
Yep.
So
that's that title. That's that title shit they're always talking about. That 13th Amendment.
Yeah, we got to understand the game that we're playing, right? It's kind of like if governments value Satanists and they're your rulers, you better understand what Satanist is at that point. So
yep.
That's why I put the property tax. That's this tribute. You know, the government collects it and then they give it to that corporation that probably has all kinds of, look at like a map art, all the generational wealth people that receive it. So at that point, we've been financing that game the whole time.
Yes. And that's why I say, you know, people are actually paying tribute to a false patriarch. That's the wrong landlord, folks. They are not your lord. And yet you treat them as if, though, by subjecting yourselves to their ID, the state ID, federal ID. And if you guys don't understand that, the Real ID Act only applies, again, to the residents. Federal, state, or municipal officers or agents whose resident presence is deemed necessary by the board, and thus you must give consideration and they must give consideration in turn. So if you're paying taxes, you must have an income on that property. That property must be used as a business.
Yeah, you can play the corporation game. So, it's challenging to be a sovereign being when people have already identified themselves as a human part. That birth certificate only works if you think you're that form. So let's talk about that birth certificate, folks. I've done so much research on this. And back in the beginning, I was on that birth certificate thing thinking that you could turn that into money. No, that is merely a record establishing the false residency and the false tribute to the false patriarch. It's all false. The outline is that the federal government cannot accept anything from a state resident unless they can accept the documentation, and they don't have anything to register the United States or the birth certificate in the United States. That says they cannot accept it. There's no place to register it. Well, it'll be like the game, how many births do you have in one lifespan? You have one.
Yep. You have two deaths. You can have two deaths.
At that point, if people understand what death is a transformation, hence the cycle of life and death. Your body's going to die, age, whatever word they want, but you can have an ego death, where your body can go through a transformation, and then you can have a self transformation, that program. So once the person, when you hear words, people would say, I had a near-death experience. You had what? A near transformation? Did you see the light? What do you mean? Yeah. Well, have you ever seen thoughts before? What do you mean? Wow, there you go. You're so desperately trying to understand the enslaved language of English that you don't realize it's not a language to be spoken. This is. But anyway, when people go to court, Commerce Court, they think for some reason, and they're usually those are the thinking type, that I'm going to beat the system. You should understand the system first. That driver's license is to give you privilege, whoever gives us the technology like cars, to drive on that land. The elites, whoever they may be, know that they're not owners. That's why they're called lords.
Yep. And 2 Packs of Sugar says the spells are many. That's why they teach you how to spell and write in cursive.
Yep. Go ahead, Ryan.
Greetings again, Ryan. We get that issue fixed? Let me check the settings. I'll check, but I don't think there's.
Sometimes when people go into Streamline, if it gives you that opening page, and if you don't say accept first time only. Like other times, you almost have to reset your whole computer, and then when it comes up again, you got to say allow.
Yeah, that might be your next step, Ryan. Try it. See, can you say something?
Be here, Ronnie. He's here. Okay,
Yeah,
Keith.
yeah,
Let's just communicate telepathic now. That's it. Keith, Ryan, we're going to communicate telepathically now.
So go ahead and try that, Ryan. Go ahead and drop down, shut your entire device down, log out, whatever, and then come back in. And the settings should ask you about your mic and audio. And I'll hang out for a bit, see how it goes. And yeah, we got a good group today. I appreciate the raid from Jack. It helps get this information out. And I think, even with 20 people in, that's still kind of low for information that's valuable that everybody should have. And I hope that's what you guys get out of that last video I just played, the Freedom Flame Burns On. Paul Revere is one of my greatest heroes. It expresses how I see that First Amendment, in that I have a great right to speak, but imperatively, exponentially, the greater right is the right of the people to know.
Well, I guess the amendment, the word meant in it, the right to speak. What language would that right be for?
Right. Well, and that's why I think they put in the freedom of expression, because we have deaf people that can't speak. We have blind people that are deaf as well, Helen Keller, but still she was able to speak.
Mm-hmm. And like that word expression, you can express. It's usually something that manifests itself in some sort of action. So yeah, I don't know necessarily it's free, but I get it. Again, that's part of the conditioning, free will. You have a will with variations to it, but one of them can be free. Even the concept of rights. Who's given that authority to tell the human race that they have rights, and for what purpose? Again,
Yep.
it's about challenging things. In this case, questioning words is things. And then once people question enough time, then when you're in that silent state and hopefully listening from within, something will reveal itself. I said, you're ready now. What do you mean? You're no longer being one of those NPC goyams or whatever. No offense to people, but unfortunately we've allowed ourselves to be classified as citizens, peasants, as they're classified themselves as nobles, people. Constitution, we the people, has nothing to do with the peasants and citizens.
Yeah,
so people, go ahead.
and that's the importance of discernment. It goes to that thing about eyes to see and ears to hear. So when you learn how to read correctly and comprehend it correctly, you end up getting a better knowing, and that's where the truth resides, in knowledge.
Well, the truth will set you free, but to do that, you would have to be away from here and looking at all the deceptions. Oh, so I could never have known truth in that form. No, you couldn't have. Again, we're quoting something from a written form. It's kind of like that horse on the truth from the on the white horse. That's an energy. That's in spirit. Revelation gives it away. John was taken up in the spirit, not the physical. Yep. So at that point, that's a spiritual conversation.
And that's what many people lack. Jeep says, what about people's right not to know? They reject the truth. They lack that spirituality. They don't want to know,
Yeah, that's why they fall into belief system. Even to know the truth, to know, forget about the truth, to know is already a fallen state. That's right. Where that tree of knowledge of good and evil, spiritual material. The tree of life is about wisdom and understanding. But unfortunately, to be here, some beings will probably overcome the physical, but yet still be entrapped in the spiritual.
Yeah. Greetings again, Ryan. We're going to try again.
Yeah.
Can
you hear me?
Perfect.
Hello. Good.
Perfect.
Welcome,
Good.
Ryan.
How you doing, brother?
I'm all right, man. How are you? Probably not that good since I heard what you were talking about.
Oh, no, we're doing great. We're doing great. My companion is quite stressed out about it. Yes, it does stress me out, but like I said, I am fully confident with the exception of that tinge that I know about corruption. But other than that, even when I had cancer, I never thought about death. I don't think about consequences, because even if we are evicted, it's going to be a lesson, and I'm going to learn from it. You know,
Right.
I've already learned from it before we even get evicted, if that's the way it goes. You know what I'm saying?
Yeah, I hear you, man. I was coming over from uh Burn the Corporate Fictions channel,
Ah,
and I
very
I caught
familiar with them.
yeah, I caught the last little bit of what you were saying before you went to break, and
Yeah.
I'm getting eviction notices too, but not through a lawyer yet.
Yeah, and that's the thing. You got to do your research, and um, you can
But
use the information I've put out as a foundation for your research, but it's not going to be the same. It's going to be quite similar, but it's not going to be the same. For instance, in remedy for Iowa, we have certain limitations as to how much you can ask for, and in other states, it's like double that. In Delaware and a couple other states, it's triple.
I'm in
So
PA.
yeah, so just do your research, and feel free to contact me. My email for everybody is down in the details section of all my videos. Um,
Okay.
wordwizard@wordwisewarriors.art. Feel free to send me an email and ask for any kind of help you want. I don't ask for any compensation. Feel free to donate whatever you want if you can. But this is all in love. Oh, no man anything but to love one another. For to love one another is to fulfill the law.
Right. Yeah, I hear you. Like the thing I'm having a problem with is it's my parents' house, but they've had it and put it in my sister's name with debt notes, and she paid $1 for the deed because my father was passing away, and they didn't want the banks to take it from my mom.
That's how they used to do it in old um, foreclosures in the old days. There's many instances where local people would gather around at those auctions, and the guy that bid $1 was the guy that used to own it. And if anybody bid him any higher, everybody's standing around there with guns and chains.
Yeah, I heard about that. That would be a good thing, but right now it is since she owns it, she dislikes me. I don't know why, but it's been a few years since I even talked to her. I don't have any contract with her, nothing, or contact, and she just wants me out of here. For I'm not bothering anybody. She lives in a different state in a different house with her husband.
And see, that's where, again, very wise. I urge everybody to do your research on this, because again, there are protections, and possession, brother, is 9/10 of the law, particularly when somebody else has equitable possession of their own home, particularly in family situations. Are you the eldest son?
No, I'm the only son.
Okay, so you're the son, and
Yes.
inherently, when you set your house in order, this is why inheritance from the father goes to the first son.
Right. That's
So
what I
check.
was thinking.
So technically, you should have been the one putting the $1 on the book.
Yeah.
It's actually the firstborn that opens up the matrix.
Well, my sister was the firstborn.
So she's the firstborn. It's just men get caught up
But
in the male part.
Right. But back in the day, it was the true heir is the son.
correct. It's only in modern time that they use the firstborn.
Yeah, communism.
And again, and again, it goes to that part about set thine house in order. The firstborn was literally meant to be for the firstborn son.
Well, I'm working on my claim.
Well, let me know if you need any help. Just send me an email. We do it all private. So
All right. Yeah, Byrne has that template up for that claim on his, if you're a member to his channel.
oh yeah, I know Ryan rather well. Him and his dad both. we don't speak often, but I'm quite familiar with his work. I do go over and watch his streams and join every now and then. And if you're
Yes.
if you're already working with him, I suggest keep working with him. And if you together between you and him have problems, then come to me and I can help input in that.
Well,
Don't.
I just seen that you had a lot more than what I could have found uh on the internet here about case law.
Well, that's just again, that's why I say this is specific to Iowa. So if you're in Pennsylvania, you can't believe me because it's
So
going to be different there.
so that's not a what do they call it for every state?
Yeah, equality of the law among the states. Yeah, see, that's what you have to assert. So if you're going to use another state's codes and remedies, you have to show that. Whereas if Pennsylvania already provides it and you're going to another state, they're going to deny it.
I don't catch what you're saying there.
So Iowa has, like I said earlier, Iowa has these statutory codes and everything. And when it comes to compensation or remedy or settlement and stuff, states vary. So if you're seeking for a remedy for Pennsylvania, but you're using Iowa code, two ways it can go. It can go detrimental to you because if Pennsylvania gives you greater remedy, you should use Pennsylvania. If you're trying to use Iowa because it gives you greater remedy, Pennsylvania won't allow it.
Right. But would it still be in the, what did you say, the transportation code? Or is that just Iowa?
No, it's everything, but you can't use that. You can't go to the federal transportation code. You have to use your state statutes in this.
So
look at your state's Landlord Tenant Act.
okay.
Every state has one.
Right. I can do that. And then I guess I can email you if I need any more help then.
Yeah, absolutely. Absolutely. And real quick, I want to address this comment been hanging for a bit because this is intriguing to me because I have certain work that I do with AI, and I'm telling you folks, this is a real picture of me that had to be AI, that I tried to get AI to kind of fix up a little bit, but it took me months to get AI to accept the short mustache because it is biased and considers that
Charlie Chaplin. They don't like Charlie Chaplin.
exactly. See, you get my point.
Yeah.
They all it's biased towards Hitler and anti-Semitism,
which is a lie.
Absolutely. So the comment here is Jeep says, I heard AI can't read cursive writing. Now I don't know that. I will believe it, but I will test it as well because I will get I will write up some cursive documents myself and send it through the scanner and see what happens.
Yeah, it won't read it because it doesn't know how to read cursive.
Yeah, that's what I'm thinking, and that's because everybody that has cursive knows how to write cursive has a different style. Even your signature is different. There's no consistency, and so that's one of the things that AI won't put up with. But see, the problem there is that I can't put up with AI's inconsistency.
Mm-hmm. Yeah, that's why it's real hard to trace your chain of title back.
Everything says I just asked ChatGPT. It said it will read it like broken English, but it challenged me to show it to it.
That's funny.
Absolutely. So anything else, guys?
No, that was it for me. If I need anything else, I'll just email you. Thanks a lot, El Pero.
You bet. Appreciate you coming up. Always be blessed, brother.
Thank you. You too. Have a good evening.
I will. How about you, Dom? We're gonna head out, and I'm gonna throw up one last video on the way out for everybody. I hope you enjoy it as well. Go ahead, Dom.
Give me a minute there, Keith.
Okay. But yeah, it's it's important, guys, to learn how to stand up for yourself. Again, the imperative of the First Amendment, the most powerful right we have. In the beginning was the Word was with God, and the Word was God. It's about speaking the truth, no matter how dangerous it is, because if it's warning of danger, everybody has a right to know it forthcoming. So,
Amen.
I guess, Keith, numerous things that you kind of just brushed over, whether it was how cancer cells work or in this thing that you call AI. AI, obviously, people, once you hear it, it's a program. It's like a calculator. It does not have the ability to process information the way we can. So you put into a program like humans, more times than not, most people are led masculine. That's their program. The intelligent part is when you become aware of your feminine side, your teachable side, and your program side. So that computers or like a calculator can process a whole bunch of numbers. It uses the language of humans, in this case, whether numbers or colors or words, and it can process it quicker, but only because we've limited ourselves.
yes. And that's what I keep pointing out. See, it's on you, folks. You're the one limiting yourself. When you give up that responsibility and hand it over to somebody else, you're limiting yourself of that responsibility, and it inhibits your growth. When you take on extra responsibilities or your own natural responsibilities, such as education and stuff, that is the imperative. When you take on that education of your own children, you know they're not going to be indoctrinated by a bullshit education system. That's where the cognitive dissonance comes from.
The indoctrination is the language. So when I say it's limiting the self, hence know thyself. The self is the ongoing program, which we call the conscious state. The language for that is called thoughts. But once we start dumbing it down with speaking language or written language, that's a dumbed down version. So now as people or young children are being indoctrinated in school, their parents are being indoctrinated in the workforce. So
Absolutely.
now I've heard you guys talk about, basically you're talking about being a householder. This is why the Indian cultures talk about once you reach a certain age, the year of release at 49. So at 50, you give up the responsibility to your firstborn. Back in the days, they used to kill all the firstborn when it was a girl opening up the matrix. So that's men, MEN structures. So now when a person goes into court, they've already got you.
Yep.
It's when you realize I'm doing most of my energy in one lifespan to fuel, feed it in this case, and shelter the form.
Yep.
Once you become aware of that, then you realize, oh, so I've been indoctrinated with the indoctrination. Yes, I have.
Yep.
Then you realize how much you're full of shit. You're not being honest with the self. This is why when people question things, it's like awareness of the self opposed to self-aware. So at this point, Richie, what's going on, Richie, Keith, what's occurring now is people are following the bouncing ball and they think they got a got you moment. I figured out the government. I said, no, it's human behavior that you need to figure out. And same with your personas, your personalities. There's nothing. Go ahead.
Part of the indoctrination, like I said, I love referencing set thine house in order, because this world is a gift to mankind. And I've done a video 6-7 years ago, or 8. No, it's been 8 or 9 years ago when I went out the Appalachian Mountains and traveled around for 7 months in a tent. And I reached this peak. I went on a trail up to a place called Frankenstein's Cliff. And when I got up to that point and I looked out and I saw the world, I knew I was in the right place, no matter where I'm at. But at that point, it was the realization that no matter where I'm at, I'm as close to God as I can be, because he's with me everywhere, at the highest point and in the lowest valleys. So when you try to sit there and say I'm homeless, that's an error. How could I be homeless? This is our home. This square thing, this is a box. This isn't a home. I belong out there in nature, not in here in commerce. Does that make sense?
Well, as long as it makes sense to you, Keith. It's actually beyond the senses, but let's entertain this for a second. When a person hears the concept, be in the world but not of it, we're talking about the vessel at that point.
Correct.
So when you hear terms like the person just gave up the ghost, the G-host. See, in biblical stories, they talk about the gods finished on the seventh day, they finish all their work. Why is that? Because they're here to play. They're playing within their creation. So now, when people start pondering, well, where do we get language from then? Where do we get all the alchemy of all the metals that we use and all that? Are we to assume that the gods, when they create everything, forgot to build civilization, or are we here to play?
Yep.
You know, it's when people want to think that they're that mortal form. You know, it's the thoughts that we use that's immortal. This is why when they introduce Sanskrit to the human race, where there's a frequency in that particular sound, and it's kind of like a singing bowl, and you can actually heal your vessel on a regular basis. Now, that's depending on the blood type and your molecules in your body. But a lot of people are going to struggle with that because they've never challenged their ongoing program. How did I get language? Go ahead, Keith.
Yeah, they don't understand that simple phrase, and it's not just in the scriptures. And it's kind of like do unto others as you would have them do unto you. It's multicultural around the world. Is to know thyself.
Mm-hmm.
No,
and then
people don't understand that. It's easy.
Well, they're not interested in understanding. It gives it away. You know, when people look at the drawing of the tree of life, on either side, there's understanding. On the other side, there's actually discernment, wisdom. For a lot of people, they're not interested in the love of wisdom, philosophy, Sophia, let alone are they truly going to understand. What I mean when I say understand, you're under the mind.
Yep.
You know, and at that point, well, then what I'm using, you're using your brains. Which one is it? Your upper brain, this is where the scholars come from, or from your gut, that's intuitive. That's the intuitive brain. Of course, we have other brains, but a lot of women usually are preset with the intuitive side because they birth the vessel in another form. And then, unfortunately, a lot of people don't grasp this. Then you jump in.
Yep. And that's another thing about set thine house in order. This is your house right here.
Mm-hmm.
This is what you use to do everything in life. This here, the intuition you're talking about, is how you feel about what you're doing. And if they connect and match, you're probably doing something good.
Well, this is where we get the concept of king and queen. This is hemispheres. People just kind of skewed it with right and wrong. No, it's right and left. You have a king and queen. Your heart could be maybe classified as a gesture. It will challenge the program. You know, but unfortunately, people are going to be led, and then we form an attachment. This is where Buddhism teaching comes in, where people realize what is suffering. For most people, suffering is not resistance to pain. It's attached to comforts and pleasures. How many people can honestly say when they decide to give up the ghost, what's their concern? What I want to say, stay here. I said, okay, so then you've really never done the true works, have you then? You've been doing a lot of material work. And then they complain when they hear about people in Hollywood doing the spiritual work. What do you think the rest of humans are doing with fucking dead carcasses? They're eating the flesh. And at that point, they wonder, I wonder why I'm not healthy. I said, well, first of all, did you honor the being in that form that got removed from it? And I don't care if it's a plant. I don't really care if it's an animal. This is why nature is actually wild and untamed. You need the letter of the laws to have boundaries over it. The letter of the laws. Land, air, water, and space. So then what are humans playing with then? Policies. So then why did they say in court, we're following the laws? Are you? You know, again, I get it, Keith. When people go to court, you see the judge there, and he's like the captain of the ship. All of those guys, and most of them are in clubs, they're actually being misled also.
Absolutely. Forgive them, for they know not what they do. That's why I had them test questions for the honorable judge, because now he's bound, you know, and I can still forgive him for he may not know what he does, but I do.
Mm-hmm. Well, in Revelation, doesn't they talk about it? If they could, they would even try to trick all the wise ones here.
Yep.
But again, it's for some people to ponder. If they get rattled at the way we speak, then the question is more for them. What are you defending then? Because really,
Absolutely agree.
there's nothing to defend. It just is what it is. But I get it. People are going to play this game. There has to be right and wrong. I said, who gave you that indoctrination of right and wrong? That's a conditioning.
Yep.
You know, I get it. It might serve in a moment. It's okay. This is more healthier than this is. But the next moment, it might shift again.
Yeah. The only thing I really see that's wrong in life is that basic commandment that thou shalt not bear false witness. So again, it goes back to in the beginning was the word was God, and the word was God. So we have to learn how to speak truth. And if we don't, we're going to be bearing false witness, even if we hold back from the truth and it allows a record to continue forward without the truth. That's still a bearing of the false witness. So it's a matter of determining when you should speak and what you should say.
Well, you have a witness within oneself.
Yep.
That subconscious is there the whole time. So that conscious state, when it presents itself to some energy, more times than not, they're going to be clever and they're going to say, okay, I already know the energy that I'm reading. I'm just going to see whether or not you're going to be true to it. So bearing false witness. For most people, if they're a crook, they act like a crook, they talk like a crook, they're being true. It's nothing to do with truth, but they're being true. Now, somebody else will say, well, Dominic, I'm a Christian. I believe love thy neighbor. I said, but don't you actually fudge up the tax system? Yeah, but Dominic, that's the system. I said, yeah, you're playing with their system.
Exactly.
Which is okay, because I play with it too, but I'm not going to profess that I actually know the truth. There's the difference. Most people speak in vain. I know the truth. I know God. I said, are you sure? God bless you? Or you're speaking in vain? How about we leave the gods alone at this particular time if we're going to play with human parts? You know, humans have a lot of issues. Some of them are beautiful. Some of them are cruel, like wars. That can be cruel, but at the same time, how many people could truly say, well, I would give up war, but wait a second, don't you like the economic gains from it? Well, yeah.
Hold on just a second, Dom.
Yeah, go ahead.
Okay, and with that, I gotta pull it to an end here. I'm gonna go ahead and pull up my last video. I hope everybody enjoys it. Dom, I really appreciate you coming up. We've had a great conversation. I hope everybody gets something out of this. It's the only reason I speak. I already have the information. This is what I'm going to present. It's for me, but me putting it out here for you is for you. So please do not believe me. Do your research so you can get beyond this before it happens to you. Be blessed, everybody. I hope you enjoy this last video. And make sure to hit those buttons. There's a PayPal link down there for anybody that wants to share some love. All is appreciated. And again, be blessed. Let me start this over here. I don't like that partial screen.
Accounted for, my name's been read, written in the ledger where the lamb was led. Did not the body, did not the blood, pay every debt in the flood of love? So tell me now, what's left to owe? When mercy calls, I can't say no. Are we too old? No man anything, just grace erase what the law might bring. If love's the all, then love fulfills all that binds all their wills. overspend. The temples fall, but the heart still whispers through it all. Render to God what is divine, and what remains is only mine. So tell me now, what's mine to keep when every truth cuts dark and deep? Are we all knowing anything? Does the blood absolve the suffering? If love's the law, then I am free. But is that law the law of me? Sold. If I am dust, I still am gold. The measure's met, the balance true. No doubt remains, save love for you. To owe no man anything? Did not the Christ pay everything? The law fulfilled, the veil torn through. Now the law